Welcome to the CEO Summit. We have just got done with an amazing talk on resilience, change management, and we are now going to hear from Devin Miller about the secrets of intellectual property, how to think about it as you're growing your company. Devin Miller is the founder of Miller IP Law. He is an innovator in the field of technology. He's been in the weeds, starting various startups, helping companies grow and develop, working with different CEOs and different companies, a long list of successes. And he's here to share with us some of his thoughts on how to be able to put an IP strategy in place, thinking about trademarks, how to grow, build a portfolio to protect your intellectual property, and then from there, how to defend it. We are happy to have you here, Devin. Appreciate your time and for being here with us at the Summit.
Hey, excited to be here. Looking forward to a fun conversation and hit on a lot of great topics, and always looking forward to a fun time. So thanks for having me on.
Oh, you're welcome. And before we dive into questions and strategies, in audience, please feel free to ask questions. If you're listening to this as a post recording, you're welcome to reach out to Devin anytime, LinkedIn, or go through his website. But before we jump into his questions, Devin, can you give us a little background on how did you get started? How did you get to this point with IP law? And some of the cases you've worked on that will give the audience a surety on your background.
Yeah, and that's a long conversation in and of itself, so I'll try and keep it at a reasonable scope. If you were to go back, probably the original journey that kind of got me into intellectual property goes back to a bit of undergraduate when I was studying at Brigham Young University. So I did a couple degrees while I was there, both in electrical engineering as well as Chinese, with the focus really being more on electrical engineering as far as a career path. And as I was getting towards the end of the electrical engineering, I basically took a step back and said, hey, I like engineering, but I don't want to be an engineer. In the sense that, a typical engineer, you're going to be on a small cog in a big wheel, in a big wheel. You're going to be on a project for a long period of time. You don't get a lot of diversity, and you tend to kind of go in that direction. And I said, that's not necessarily what I want to do when I grow up. So then it was kind of the crossroads. I had a couple interests. One was I thought doing entrepreneurship, startups, small businesses, and kind of going down that route was interesting, as well as I thought the legal aspect of doing a lot of intellectual property with working with startups and small businesses and helping them to protect it, and doing the law side was interesting as well. So kind of, with that as a bit of a crossroads, rather than picking one or the other, I split the middle, and I went off to do graduate school, and I did both a law degree as well as an MBA degree, a Master's of Business Administration, and that's kind of been my, I guess, mantra for all of my career has really been, I've always been a full-time attorney ever since law school and doing law clerkships even during law school. And then I've always done startups and small businesses along the way as well. And so I went off, did law school, did the MBA, started a business during that period of time, came out of school, started working for a large law firm, and then about 5 or so years ago, really wanted to focus more on startups and small businesses. So started the Miller IP Laws, the law firm, to kind of have more of that focus on helping startups and small businesses get the same level of service that I was doing when I was working for clients, including an Amazon or an Intel or Red Hat and Ford and others.
Now, thanks for sharing that. It positions you really well to help businesses and to do the legal work as well, since you have a pretty good education and experience with both. Jumping into IP, why is it so important for startups and companies to have an IP strategy, to understand the IP laws as they get started?
Yeah, and I'll caveat it with, I don't know that it is important to every business, and there are exceptions to the rule, but for the vast majority, if you were to take the very high-level concept of what intellectual property is, I would back up and say most people get if you're talking about real property. So you can own a car, you can own a house, you can, own those type of things that are physical and tangible. The difficulty often is when you're with a business is there's a lot of intangibles that aren't physical. So as an example, a brand. Well, a brand, has physical manifestations. You can see a logo or you can see it printed, but how do you own, owning the brand is a bit different. There isn't a physical thing that is a brand outside of trademarks we'll get into, but that's, it's a bit more of a abstract idea. And same thing for inventions. If you're creating something that is new and innovative and unique, most of your value is going to be more on the time, money, and effort to develop it, to figure it out. And the difficulty is just like kind of a magic trick where once it's figured out, once you know how it's done, it's a lot easier to reverse engineer, to recreate. And yet that initial time, money, and effort to go into creating it is oftentimes that value. And so again, it's kind of that intellectual property, hence the name where it comes from, of how do you capture a lot of that value. And even the same thing with books. If you're to write a book or do a movie, hey, once a book is out there, people can, right click, copy and paste, get the digital file, and away they go. And yet it takes a lot of time to write that book or to make that movie. And so at the very core of the essence of intellectual property is it is a ability for having, intellectual or to protect the intellectual aspects of your business, whether that's a brand, whether it's it's the inventions that you create, whether it's the creative things in nature. Gives you both the ability to capture that value, and so you can have it as something that's more tangible, investable, licensable. You can sell it, as well as the ability to protect it against others from coming along and leveraging all the work that you put into something.
And when should you start thinking about protecting that intellectual property in the life cycle of your company, your startup? When's a good time to start thinking about that?
Yeah, and I'd back up to maybe answer your question a bit, just kind of for the audience. When you're looking at intellectual property, I touched on them. There are kind of really three primary aspects. So there's patents, trademarks, copyrights. Patents are going to go towards an invention, something has a functionality that does something. Trademarks are going to go towards a brand, so name of a product, a name of a company, catchphrase, logo, those type of things. And copyrights are going to go towards creative. So a book, a sculpture, a painting, a photo, a video, those things all fall into creatives and their copyrights. And so the reason I give that kind of as a backdrop is it a bit depends on when you should start thinking about it is kind of what the business is and what the core is. And so if I were to take a step back, the first thing I'd look at is what is the core value of your business. And that will kind of, put you on the different direction. If you are a technology company or an innovative company and you're creating new and cool and different breakthrough products, and that can be everything from software, hardware, electronics, food, pharmaceuticals, across the board. But if you're an innovative company, then you're going to think about patents versus now let's say you're a branding company and you do a really great job of getting out there, it's differentiating yourself, getting people's attention. You think of Disney, you think of Marvel, you think of Pepsi, Coke, Apple. They have a huge brand and a lot of following, and a lot of what their value is tied up with that name recognition. And so now when you're looking at when you should get started, it's a difficult question. I don't know there is one definitive answer, but probably the best rule of thumb or answer that I've come up with is or what I would call the ouch factor. So in other words, if you are investing enough time, money, and effort in your business for whatever it is, that if somebody were to come along, and if you're a technology company, somebody were to come along and knock off or copy what your innovation is, or if somebody were to come along and they were to copy your brand, if it has that ouch factor to say, I've invested enough time, money, and effort in this that if somebody were to knock that off or copy it, it's going to be impactful to the business, the revenue, and those type of things. You've reached the point where you've invested enough time, money, and effort that you've created that value that now you're going to want to protect it. But on the other hand, you're saying, yeah, it's kind of a cool or side gig or something fun I do on the side, but if somebody could come along, yeah, I wouldn't be happy. But on the other hand, I could rebrand or I could create something else different, or, the innovation it was just really a rough prototype, those type of things. Then you could probably say you can hold off for a bit. So I'm going to make it so that if somebody knocks it off or copies it, going to have that ouch, versus if you haven't reached that point yet, that's probably the best rule of thumb.
And what are some of the misconceptions as people are thinking about IP law that you've seen and encountered that people have?
Yeah, I mean, a few, and it does kind of drill down, depends on the areas of intellectual property. So I'll give you a few, maybe just a couple from each of the three main areas. So if you were to take patents as an example, there's a few. The biggest misconception that floats around on the internet, and their genesis as to why it was legitimate at one point in time a while back, but is, hey, all you need to do is what's called a poor man's patent. And that is, you write it to, you write up your invention, you draw it up, you put it in a self-addressed envelope, you sign it or send it to yourself, and as long as you never open that, never break the seal, you're protected and covered. And the real answer is that's worth about as much as the stamp. In other words, it's better than absolutely nothing, but not by much. And so there's kind of that conception of, well, I can just do that, and I'm equally protected. That wouldn't be the case. Another couple things on patents is the thing you have to think about is it is a first to file system, not a first to invent system. Now, what does that mean? That means that the presumption is whoever files on a patent first is the presumptive inventor and is going to have that presumption of being the one that owns it. So if you come up with a really cool invention, you never file it, never do anything with it, somebody else comes along and files a patent application on it, they're in a lot better situation to claim ownership to it. Now, there are exceptions if you can prove, as an example, hey, I really came out with this first, or if they stole it from me and it was corporate espionage or something of that nature, you can have some limited ability to pursue it, but it is pretty limited. It's going to cost you a lot of time, money, and effort to prove that. Now, if you're to switch to trademarks, the conception or some of the misconceptions with trademarks when you get into the branding side is, hey, all I have to do is go out. If I'm the first person to come up with a brand, if I start using it out in the marketplace, I should be good. There is some legitimacy or truth to that, but there's a lot of exceptions to that. So if you're to take as an example, let's say you started a pizza company and you went to Chicago and you named it ABC Pizza. Awesome pizza. You put it out there in the marketplace. You're the first person to start using ABC Pizza. You say, okay, first one out in the marketplace, I'm good to go. And you keep doing it, and somebody else says, hey, I love that brand. I'm going to go to California and I'm going to start ABC Pizza. As long as you don't have overlapping geographic locations, and so if you're in Chicago, you're the first person to use it. You got to keep using it in Chicago, but then you don't get to use it anywhere else, and vice versa. Somebody else comes along in a different geographic location, they are perfectly fine to do that. Versus if you do a trademark registration, you have it against that ownership in all 50 states. And so that's kind of a misconception. The other one that is, or kind of when you go along with trademarks, and then I'll pause a bit, is, there's a difference between a business registration, a URL, and a trademark. All three are separate, all are beneficial with your business, but just because you register the name of your business with the state doesn't give you any ownership rights or rights to using that name. That basically just means, hey, the state did a check to make sure you can properly pay taxes, and they can keep you, they can separate you from the other businesses out there for tax purposes. URL is just, hey, I own a www.whatever. Doesn't mean that you have the rights to that trademark. It just simply means that you purchased the URL, and vice versa. You can have a trademark. It doesn't automatically give you the rights to own the URL because it can be separate. So those are kind of some of the misconceptions on both patents and trademarks, and I'll pause there and kind of see if that makes sense, and I'm happy to dive through on a couple of misconceptions of copyrights as well.
Yeah, and before we dive into those, one last question on the foundation here. Sure. Startups and businesses pivot and change their minds. When do you feel it's the right time to start the process of protecting your IP so that you don't you have a solid strategy instead of a pivoted strategy of protection?
Yeah, and that's always a hard question in the sense that businesses are typically always evolving, always iterating. You'll have generation 1 or 2 of the business, and then you'll figure out maybe you miss a market or you need to pivot or your customers are really over here, and so it's always an iterative. So I don't know that there's because businesses are never fully defined or they're always evolving, your intellectual property along with everything else with your business is going to be evolving along with it. Now, kind of with that said, if you're to look at, I'll caveat it, and it kind of breaks down a bit into the different types of intellectual property as far as when you would want to consider doing it. Patents, the earliest you can do a patent is when you reach a point that's called conceptual reduction of practice. What that basically means is you have to be able to explain your innovation to a level that somebody else in the industry, given enough time, money, and effort, would be able to go out and recreate your invention. If you haven't got to that point, so it's kind of a high level, kind of cool idea, but I really don't know how it worked, you're not at the point that you could even pursue a patent. The other flip side to that is too late is on the patent side is anytime you, or I guess there are two things that are too late. If as I mentioned, first to file system, somebody else sees your product, comes along or puts it out, even or after, or files for a patent before you've just really lost the right to pursue it. And so you always kind of got to gauge the competitive landscape and how likely is it that somebody else is going to come along and independently come up with a similar idea, or they're going to knock you off and pursue that. The other one you've got to be considerate on as far as kind of timing on patents is there is a rule of patents that anytime you put something out in the public, you have a 1-year time clock within which you can file a patent on it. So if you put it up on a website, you do a white paper, you do a presentation, you go to trade shows, you offer it for sale, any of those kind of activities, putting it out in the public, you now got that 1-year time clock ticking that you can file a patent. You miss that window, you've now just donated your invention to the public. And so those are kind of ones where once you reach the point where you put in enough effort to reduce it to practice that you could explain it to a level that somebody could understand it, you can start going, and it's probably by that point, it's good to at least get the process going, and you definitely don't want to miss that 1-year window of after you put out in the public that you wouldn't be able to pursue it further.
Is that
trademark?
Same for trademarks?
Oh, sorry, go ahead.
Oh, is that same for trademarks and copyright?
Not exactly. And so trademarks, the presumption of a first to file still holds true. Whoever files for a trademark is going to be in the best position to secure it. There are some minor exceptions that are under common law or state law that you can, if you're using it first, you can continue to use it in the areas that you're currently operating, but it really limits your ability. So generally, when you're looking at trademarks, you're going to look at and say, okay, when have I put in enough or time and effort with the branding side, and so that makes this trademark valuable? So near term is going to be valuable. So if you are getting to a point where you're going to start doing products, you're going to start doing product labeling, you're going to have it, the name of the product that's putting on packaging or on the product itself. You're doing a investment in getting a website up and going. You're investing a lot in paid advertising or Facebook marketing or content, all of those things. In other words, you're starting to invest in the brand more than just hey, we've got a cool logo and we think it's an interesting thing, and I updated my LinkedIn profile. But if you're now actually you're actually putting it out there and using the brand as part of the business, that's probably about the time that you're going to want to consider to protect it. Now, the one caveat I'll give is you would want to, before you put in all that time and effort, put in earlier on, make sure that you actually can use that brand. So sometimes what will be the difficulty is people have a brand that they love, they get married to, they think it's a great idea, they'll start getting all of those wheels in motion, they'll get all of their products ready to go, they'll start developing their website and all those type of things, and then they'll do a quick Google search to make sure, hey, this exact wording and this exact brand isn't taken or isn't already out there. But what they're unaware of is that there are, the threshold for whether or not you infringe someone else's trademark or you can get your trademark yourself is what's called confusingly similar. And that basically means, hey, if a consumer were out there and they were to see your brand and another brand that's already out there, would they think there's an association, there's a tie together, that those businesses are related? If there are, then you can't trademark that brand. And so you do want to do a homework on the back or the front end before you put in all that effort to at least say, hey, is this brand available? Can I use it? Is it likely I'm going to infringe someone else's trademark, or I'm going to get a rejection and never be able to get it? So you don't go and put in all that time and effort. So it's kind of broken into two phases of, one, see if the brand is available. If it's available, then start doing some of that preparatory work. As you're getting closer to or utilizing that preparatory work, you're probably going to want to file a trademark to make sure you're protected.
And how close is it that, a misconception here, or maybe it isn't, if someone wants the same name or using the same name, how close can they be, or differentiated can they be? Who draws the line on that? So there could
Yeah,
be
I
two
mean,
people
it
with the
is
same name.
it's a spectrum, and so there isn't a definitive bright line that they just say, you're 80%, and I don't even know how you would calculate 80% close, but it goes back to that confusingly similar standard, and it's a bit of a, hey, it's a human individual, it's an examiner at the trademark office, or if you're in a lawsuit, it's a judge or jury. But generally, if you're to look and say, they're going to break down a few criteria to try and define whether or not it's confusingly similar and whether or not you're too close. One is going to be the products and services that you're offering. So in other words, you have Apple that's out there, and the first thing you think of a lot of times with Apple is consumer goods, smartphones, electronics, and those type of things. Theoretically, if you wanted to go and start Apple restaurants, that you're going to sell a whole bunch of Apple products for restaurants, you're probably far enough afield from Apple now. That's an example. Don't go trying to rip off or try and mimic Apple because they're very but that type of an idea of if your products are fairly different, dissimilar, if you're an automotive company versus a restaurant versus a consumer electronics versus a boating company, those are all going to be able to coexist, even if they're the exact same name or a very similar name, just because generally a consumer is not going to say, hey, an automotive company is now going to go and open up a restaurant. They're not going to be confused with the same or similar name between an automotive company and a restaurant. Vice versa, if you have, as an example, a wearable technology, so let's say you create a wristband that's on your wrist, and you use the same name as a company that has smartphones, then you're getting a lot closer because people are going to, consumers are going to say, hey, it's not outside the norm that a phone manufacturer is also going to make electronics that go on your wrist. And so while it's not the exact same product, it's much similar. So one of the criteria is how similar or dissimilar is the product or service that's being offered for the brand. The other thing they're going to look at is kind of what is the spelling or the name of the company or the product that you're trademarking. So if you were to go out and you wanted to sell athletic wear, sports gear, and apparel, and the spelling of your company was Nikee, really similar to Nike, but you have an extra E, people are still going to get confused that that's going to be too similar because they're going to look at it and say, hey, this is probably related to or otherwise associated with Nike, even if it's a slightly different spelling. Versus if you're the founder of Adidas, yeah, you have the same products, you're going to be a lot of the same services and products that you're offering, but Adidas versus Nike, people aren't going to look at that and say, hey, different spelling, different word, different meaning, same products, but they're not going to be confused. And so generally it's the spelling or the meaning of the word and how different that is, as well as the products and services, and those two kind of combine together to make that confusingly similar standard that they use to measure against.
Thanks for explaining that. So going in a little bit, we're gonna do a deep dive into trademarks, and then we'll do a patents
Sure.
with the time we have here. So if a business is ready to talk about trademarking their name or a phrase, what are the steps they should go about doing this to make sure that they're protected and that they can scale with them as they grow their business?
Yeah, the first thing that, and almost taking one step back, but here to answer your question is first is the realization there are different types of trademarks. So generally there are two different types of trademarks, separate applications, separate trademarks. One is called a word mark, the other one's called a design mark. So a word mark is going to be a word or a phrase. Like it sounds, it's going to protect that usage of the word or phrase, versus a design mark is going to protect something that's aesthetic in nature, typically a logo or something of that nature. So when you're looking at what you could protect as far as trademarks go, you're going to break that down first. And so to give you an example, going back to Nike, Nike has the trademark for the word Nike. Doesn't matter the color font or the font style, if you use the word Nike, they have that protected as the word. They also have the Nike swoosh, which is aesthetic in nature. You see that, iconic swoosh, and that's going to be a design mark. And so when you're looking at getting started on trademarks, taking a step back and saying, hey, where is my brand identity? Is it really more the logo, something that's a cool icon, something that has a specific look and feel to it? Or is it more the word or the phrase, the catchphrase for the business or for the product? Now, it can be both. In other words, you can be Nike and you can have the trademark for the word Nike and have the Nike swoosh and have both. But sometimes it may be, as you're starting out, it's really more one or the other. It's really, we have a unique logo that we're going to plaster all over everywhere, and that's going to be what is the brand, or maybe the name of the company is cool and unique, and we want to protect that. So that's kind of the first thing to get started, is identifying what is your brand, what is it that you're going to be putting that marketing and that campaign around, and then how do you start to go about doing that. Then once you get that in place, once you figure out, okay, we're either the word, the design, or both, then you're going to go out and do a search. You can hire an attorney that does a trademark search, or you can go out and try to do it yourself, but you're going to look at going out and searching and saying, okay, is this already out there? Is there anything that's out there that's or probably too similar to what we're doing? Google search is a good place to start. It's not the end-all be-all, because there's a lot of things that you don't necessarily catch on the first page of Google that are still trademarked and they're still out there. But you can start with Google. You can then go to the trademark databases if you know how to navigate those. They're not very easy to navigate and not very well set up. And that's why a lot of times we'll have an attorney do the search when you're getting more finalized. But you'll do a search. If it looks like it's clear from there, then you're going to have an attorney that's going to get the details of your trademark, prepare it, file it. It then takes about a year to go through the examination process with the trademark office to determine trademarkability. And if you're successful, then they issue a registered trademark that you can start or continue to use.
And are there companies that try to file trademarks on? Do you have to have a business to file a trademark? Do you have people out there looking at brands and there's no trademark and they just file them, or do you have
So filing versus getting a trademark are two different things. So you can both legitimately or non-legitimately, you can file a trademark application as intent to use. Intent to use basically means, hey, we haven't started using this trademark for a product or service yet, but we are preparing to do so, and we want to get it secured so that we don't put in all the time, money, and effort to build that brand, to get the company up and going, only to have somebody come along and grab it first, type of a thing. So you can file as intent to use. So filing it, or if you just want to go and try and blast out a whole bunch of, hey, I'm going to try and gobble up a whole bunch of what I think are great names, you can file as an intent to use trademark applications across the board. The difference is at some point, if you file as intent to use, when your trademark gets allowed, you still have to show that you are using it out in the marketplace. So there's a requirement that you have to submit specimens, evidence, or what are called specimens, that show, hey, we are actually using this for the product and service that we filed for. And that can be, here's our website and here's where it's for sale, or here's our storefront, or here's, however you can say that you're using the trademark. So if you're to file one, and really no intent to use it, and you never did anything more with it, it's never going to get all the way through the trademark process, because when you hit that final hurdle of or submitting that evidence that you're using it, you're gonna fail, or they're gonna look at that and say, no, you're not using it, therefore you're not able to get the trademark. So you can file for them. You can, or initially do it without having to use it, but at some point you're still going to have to substantiate and use it.
Okay. And then trademarks around expanding internationally, how does that work? Are they two separate processes?
For all three of the areas of intellectual property, it is a country by country specific basis. So you're not, whether it's a patent or a trademark, you're not able to just file a international or a worldwide patent or a worldwide trademark. And the reason, or a couple reasons being, is every country has a bit of their own standards. There are a lot of similarities, but they have different standards for how they determine trademark or patentability. And as well as they're saying that, there's different fees, it has to go through different examinations. And so for each of that, you do have to file in each country by countries differently. Now, EU as a block minus Great Britain, you can, on both patents and trademarks, you can typically file for EU as a block as opposed to each individual country within the EU. That's really about the only exception outside of the EU. It's a country by country. And so you're going to, generally, or we'll have people that are come in, I have clients that will say, hey, I want to protect this brand worldwide, or I want to protect my invention worldwide. I want to get it in every country. Well, even the biggest companies, you take an Amazon or an Apple or a Pepsi or a Coke or a Disney or whatever, they don't file in every country throughout the whole world because their consumers just aren't in every country throughout the world, or it's not a good enough investment for a return on it to file. So they're going to, every country you're going to look and say, where is my consumer base? Where are I likely to sell my product or service? and then you're going to say based on that consumer, if hey, 90, worry about the U.S. and for the other 5%, you're just going to compete without having that additional protection or layer for your business. On the other hand, if you're saying, hey, 40% of my consumers are going to be in the U.S., 30% in Canada, 10% in Europe, and the rest are somewhere else, then you may do U.S., Canada, and Europe because those are your predominant markets, and then you're gonna not do that for the rest. And so it's one where it is country by country specific on that basis, and then you're gonna look at and see for your business where your consumer, where is your business, and then look to protect it in those areas.
Oh, thanks for sharing that. And then just one more topic on trademarks versus copyrights, so people understand. You've delved down into trademarks about naming, phrases, copyright, how to distinguish that and when to use that.
Yeah, and that kind of the very easiest rule of thumb is patents are inventions. Functionality does something. Trademarks are for brands. Copyrights are for creatives. And if you can really think about what are you looking to protect, because you'll have people that come into our office and they'll say, hey, I've got a really great invention. I want to go get a trademark. And I say, what you really want to do is probably get a patent on it because that's going to protect the invention. And so if you can really kind of break it into those three categories of what is it that you're wanting to protect for your business, and sometimes there's an overlap. You'll have a great product. You want to protect the product with a patent. You'll have a great, catchy product name, and that falls under trademarks. And maybe you have some really iconic imagery you're going to use for marketing, and that falls under copyrights. So there may be overlap as far as you needing multiple avenues, but if you can kind of break it down into, for those areas, I want to either protect an invention, so I get a patent, want to protect a brand, so I get a trademark, or I want to protect something that's creative, I'm going to do a copyright. Kind of follow those three, then that usually helps to delineate out what you're needing.
Where would video content and book article content fit into the three?
Yeah, so that's really going to be more on something that's creative in nature. So if you think of a video, a book, a podcast, a movie, a sculpture, a painting, all of those things kind of takes that creative in nature. So it's not really an innovation. If you think of a book is a physical component, so just paper that's bound, and those have been around forever. The content is really in that creative nature of, hey, I wrote out a really engaging story and I want to make sure that's protected. Or, hey, I filmed a great video that's blowing up on TikTok. Well, videos have been around for forever, so it's not really an innovation, but it's the content, so it's that creative in nature. So if you're to take those creativity in nature with that sculpture, painting, book, movie, video, all those fall under copyrights.
And how do you, how does copyright law work a little bit so we understand, what you have to file for copyright, you file the whole book, you file the video, what is protected? Give us a little, basics on that. Yeah,
so a few things in there. One is copyrights technically don't have to be registered. Now, there's a benefits to filing it, so don't just, everybody listening, don't just simply say, oh, he said I don't have to register it, I'm good. So copyrights, inherently when you create the whatever product it is or whatever the creative or material it is, you do have some inherent rights to you created it, therefore you're the owner of it. Now the reason why you typically register it is a couple. One is if you ever want to go out and enforce it, so somebody knocks off your creative, they go and copy your book or whatever. In order to go into the court of law, you have to have that registration. So even though you can say, yes, I created it and approve it and I own it, if you want to enforce it, there's a requirement that you have to register it. The second thing is if you ever want to license it. So if you're to take Disney, Disney has a ton of creative things in nature, right? They have all of their characters. They have their movies. They then go out and license it to plush toys or to books or to lunchboxes or to whatever it is. A lot of that is licensing. Well, what you're licensing is really a registered copyright to use it for at least a specific, for specific product or specific service. And so when you're doing it, copyrights, you don't have to register them. You do have some of those inherent rights, but if your intent is to ever enforce it against anybody, or if you're wanting to go out and license it, you're going to have to register it. Now, if all you want to do is, hey, I created this, I want to be able to go out and I want to sell it, and I don't care if people copy it or I don't care if people use it, then you don't need to file that copyright registration. The kind of now one other thing that you hit on that's a follow-on to that, which is for copyrights, is now as far as the registration process, it's pretty simple. Copyrights, out of all three, copyright's going to be the easiest. Generally, you're going to go and you're going to file the copyright with the Copyright Office. It's actually part of the Library of Congress, so when you file it, it will get put as part of the Library of Congress for that registration, so it's under a different office than the other two, and they're not going to do a lot of examination. But the standard for whether or not something is copyrightable is it wasn't yours, it was one that you have to create it. So you can't just simply go and take someone else's photo or picture or video or book that they may not have ever registered and try and run out and get it. You didn't create it, therefore you're not the owner and you can't get a copyright. But two is if you're taking a lot of work that's an inspirational work. So you take a picture, and yes, I changed it a little bit, but really at the end of the day, the original picture was by someone else, and the vast majority of what is part of that creative nature is somebody else's. You can't go and copyright someone else's work. You can only sometimes copyright the aspects that you changed in. So there's kind of that variable nature. One, it has to be that you created it. Two, it has to be unique enough that it's not just simply mimicking what else is already out there.
And while we're on the topic of copyrights, with ChatGPT and AI and content creation, I know that's probably in the top of mind for a lot of different companies and CEOs. Using that to create articles or to create books with your own knowledge plus that adds on, what kind of challenges that pose with copyright issues? Because you don't know if you use someone's content, but you use yours for sure, and ChatGPT may have helped you. Any recommendations there?
It is a bit of the Wild West right now in the sense that it is a new area of law, and I'll give you a few guidelines. But if I were to say, law always lags behind everything else, and so usually things come out, new technology, new way of doing things, a new creative, and then the law comes along afterwards and kind of figures out how the law applies to it. And so with a lot of this, you're seeing everything from big companies like a Meta or that are going out and suing or getting sued for some of that creative in nature because it is still the Wild West. And the biggest genesis or the biggest problem is when you go out, if you write something and it comes out of your own mind, your own inspiration, you know the source of where it comes from. If you go to ChatGPT or, take whatever, there's a lot, more and more that are coming out, you don't know what it's using as far as that source or for that inspiration, because AI doesn't come up with things out of thin air. It uses materials that it's training from or uses examples, and it may aggregate and mix that together and do it in a new format. But you don't know if, as an example, when you have it create a new AI generated image, where did it get those training materials? Is it taking 80% of an image that's already out there and then combining the other 20% from other images? That can create an issue, versus if it's taking 500 images and taking 1% of each of those, or 0.5% of each of those images, then you're creating something that's more new in nature. So one of the issues that is often the problem is you don't know the content or the source of how much the AI is taking and where it's taking it from as to whether or not you're going to infringe someone else's intellectual property. Now the other question is, okay, let's say we get past all of that. We say, okay, it is using enough of disparate sources and creating or combining it enough that it probably isn't going to infringe someone else's copyright. Then the question is as far as own versus AI. Well, AI can't own anything. It's not an individual. It's not a human entity. It's not something that's living. So it really can't be owned. And so generally right now where it's coming out is if you're the person that prompted AI, so you create or instructions, you tell it how to modify it, how to create it, what is the instructions. Generally right now it's coming out more with the court cases that you still own it because you're the one that originally gave those promptings and instructions to AI as to what to create and how to create it and how to modify it. But it's still Wild West and it's still a bit of an unknown. So generally the guidelines I would typically give people is the more that you rely on it, the more you're likely to open yourself up to possible issues because you don't know the source, you don't know where it's coming from. And so the more of what your material and your content you're using that isn't created by yourself, you just have to realize there may be those legal issues down the road because you don't know where it came from. Other than AI spit it out and gave it to you, it may present issues or it may be fine.
Thanks for sharing that. So we have a little bit more time, not that much time left here, but patents. Suggestions, strategies that you would apply for entrepreneurs, company CEOs thinking about patents? When should they start doing it? What's the process like? Uh,
Yeah,
and
that's a
then,
long conversation. I'll give a few guidelines where or because I could go on for a long period of time and I'd probably find it interesting and nobody else would. First thing is maybe to think about is whether or not something is patentable, and that's kind of first hurdle you're going to get to is whether or not if you create something you think is maybe new or unique or interesting, is it patentable? Well, there's really two primary standards for patentability. There's a few others, but the two primary ones are what's called novelty and obviousness. Novelty basically means has anybody else previously invented this? Somebody's already invented it. You can't get a patent on something that's already invented. Obviousness basically means, okay, well, not one person's invented it, but if you were to take two or more things that are already out there in the marketplace, if all you're doing is putting those together in an obvious way, you're really not adding anything new or unique or innovative, again, it's not going to meet those thresholds for patentability. So the first thing is whether you're a startup or business owner, a solo inventor, side hustle, garage inventor, or a bigger company, you're going to look and say, does it reasonably look like it would meet those two criteria? Are we aware of any other inventions already out there that have already done this, or am I really just combining two or more things that are already out there in an obvious way? If you get to that point, you say, no, I think I've created something new, then you're going to go about and you're likely going to have an attorney because it's a lot of specific and unique language, but you're going to go about having a patent application prepared. And this is a excruciatingly detailed document that shows all the different intricacies, how it works, the different variations. You're going to write it up, you're going to show figures, and you're going to have that all filed as a patent application. And then once you file it, you get to sit for about a year to year and a half. You're going to be in a queue as you wait for the government to work to the top of the queue. And then it's going to go through examination where an examiner at the patent office is going to look at it for those standards and whether or not it meets patentability, and they'll either come back and, yep, you can get a patent. You may argue about a bit back and forth as to the scope or how broad or narrow it is, or it will get rejected and you'll say, nope, it looks like it's already invented out there. It doesn't meet one of those standards. So that's kind of, in a general sense, that process that you're going to be looking at as far as getting a patent. And beyond that, the other guidance I'd give is, not everything that's cool is necessarily worth getting a patent on. In other words, you can have as an engineer, as an inventor or something, you can have a lot of great ideas that may be really good, maybe kind of a cool factor to it. It doesn't always reflect in the marketplace as far as having that value or people being willing to pay for it. And so always make sure as you're having these cool inventions or ideas or things that you may want to pursue, does it have that market applicability? Does it have that viability? Can you build a business around it? And if the answer is probably not, then why you may be able to get a patent on it, it doesn't make sense to invest in it. And vice versa. No, this has a good market opportunity, good viability. I could see how I could go out and why people would sell it and how much they would cost and everything of that nature. Then you get to the point of, okay, now I may want to protect this.
well, true expert that knows the space in and out. We appreciate your time. We're kind of running out of time right now, but I mean, for the audience that's listening and those that will be listening, if you have any patent, trademark, copyright questions, need a strategy, scaling it globally, trying to be able to figure out when to start doing it, and then going through the whole process, I don't see a better person than reaching out to Devin Miller and his company with his business experience. Devin, if you have any lasting words or comments you want to say to the audience today, I'll give you a chance. Anything you'd like to tell them?
Yeah, I mean, it would probably be just general business advice, which is, so I've worked with a ton of startups and small businesses, have a podcast, have a lot of other things, so I've had a chance to talk with a ton of them. And the overall takeaway, if I were to say the number one mistake or the things that people tend to regret is not getting started earlier or not diving in. I mean, you can always come up with a ton of reasons why timing's not right, the economy's not doing well, or I have a full-time job, or I think, the technology's not there, I don't know how to do it. There's always plenty of reasons, and some of them are legitimate, but if you always are coming up with those reasons why you shouldn't get started, even if you get started later on, you'll always look back and wish you got started earlier. So there's almost always a path to get started, whether it's doing it as a side hustle, getting a business going, finding people to work with or anything else. But getting started now is going to be the thing that I think is the biggest takeaway that I always see from a lot of different business owners.
Well, I appreciate that. So get started with your business, grow that. If you have existing business, start thinking through the IP, intellectual property strategy that you're going to put in place, and then protect your efforts of what you're doing. So we thank you, Devin, for presenting, for participating, for answering tons of questions. We appreciate the audience for listening, especially those that will be listening. We'll be able to learn a lot from this session, and I am sure we'll include Devin on other accelerators and master classes. He is a thought leader in this space. So I appreciate, Devin, your time.
Thank you for having me on. It was an awesome conversation.
And thank you, audience, as well. And Devin, if you stay on, we'll make sure that the presentation gets uploaded. But thank you, everybody, and we have one more session after this for the CEO Summit. We'll see you later.